Hi, my name is Bill Brush, and I'm the president and founder of Cut Unnecessary Regulatory Burden. I'd like to pose a question. Is APCO in violation of its license and state property law? Well, that's the subject we're going to cover today and try together to determine what the answer is. APCO's regulatory authority is limited to its property rights. In 2010, the Commission wrote, "The Commission has regulatory authority only over the licensee and thus can administer and enforce the terms of the license only through the licensee and the licensee's state property rights. Project boundaries delineate the geographic extent of the lands and facilities that the license identifies as comprising the project, for which the licensee must hold the rights necessary to carry out project purposes." The award of an SMP cannot change property rights. In 2013, the Commission wrote, "Whatever rights an entity has in lands within the project boundary, whether conferred by deed, lease, easement, or other conveyance, will not be altered by our action regarding this SMP." And in 14, please note the SMP applies only to those lands in the project boundary where Appalachian Power has property rights. The licensee has no authority to regulate construction on privately owned lands unless the property owner has given the company those rights. That's a statement that Commissioner LaFleur of the FERC wrote to Congressman Robert Hurt in December of 2014. The FERC asks property rights be resolved in a court of appropriate jurisdiction. They've reinforced that numerous times here at Smith Mountain Lake and in other projects throughout the nation. In 2005, when our SMP was awarded by the FERC, if there's a question concerning property rights, it will have to be resolved between the property owner and Appalachian in a property law action in a court of appropriate jurisdiction. In 2013, any disputes regarding property rights are not within the Commission's jurisdiction, rather they are matters for state courts to resolve. And with the award of the latest SMP, the licensee is required by Standard License Article 5 to acquire and retain all rights necessary to carry out project purposes, and any questions concerning the specific property rights would best be resolved in a court of appropriate jurisdiction. Clearly, FERC is telling Appalachian Power, resolve these disputes in state court because property issues are a state matter. Well, we're going to visit drawings again, and we'll make a statement that Appalachian's 2008 project drawings do not meet their license requirements. Why is this important? Because those drawings contain a certification. Let me read note 1 in the center of the page. Licensee has obtained all flowage rights necessary for adequate operation of the project, either in fee title or easements. All property records are kept on file with the licensee. That's Appalachian's words, and those words are not truthful. Their drawings, furthermore, fail to completely and accurately disclose its property interests, and they fail because it doesn't meet the appropriate CFR, Code of Federal Regulation. Here is the 2008 project drawing that was submitted by Appalachian to the FERC. This is where the Blackwater meets the Roanoke River. This particular area here is the water's edge. This is the Smith Mountain, and here is the raceway and dam into Leesville Lake. Well, carefully look at this drawing, and you'll see there are no notes on it of any consequence. There is no parcel information. There is no flowage right information. You couldn't discern from this diagram whether Appalachian owns all this land, someone else owns it, or it's in conservation easement. When you compare this drawing with the next drawing, you'll see what drawings are supposed to look like. Again, this drawing was drawn in 1967 and submitted as part of the original project. Here is the Water's Edge subdivision, and here are notes over on this side that correspond to the various parcels in the project shown here and here. Those parcels contain the land under the water and along the shorelines, and the notes to the right describe exactly what flowage rights apply to which parcel. That's something that the 2008 drawings fail to do, and consequently they do not meet the license requirements. The problem with that is that the FERC now doesn't understand who owns what, or who has flowage rights, or what lands Appalachian owns, and the certification that we read 2 slides back, where it says Appalachian has the rights necessary to adequately operate this project, it's a false statement. Well, now let's visit some precedent-setting court cases from the Supreme Court of Virginia. The first one, Brown v. Haley, 1987. The justices ruled, when a landowner conveys a portion of his land, he impliedly conveys an easement for any use that is continuous, apparent, and reasonably necessary for the enjoyment of the property conveyed. Absent express restrictions imposed by the terms of the grant, a grantor of property conveys everything that is necessary for the beneficial use and enjoyment of the property. And this last one especially applies to us, where the parties to a land transaction contemplate that the purchasers will have access to the water for recreational purposes, and where such access adds materially to the value of the property conveyed, use of the property retained for access to the waters is reasonably necessary for the beneficial use and enjoyment of the property conveyed. That's exactly what the flowage easement told us. We retain the rights to use these properties for access to the waters for recreational purposes, and we could use those properties for that purpose so long as it didn't interfere with Appalachian's ability to flood and operate the project. The next case the Supreme Court of Virginia heard was in 2001, and it was the Smith Mountain Lake Yacht Club versus Rahmacher. This easement did not convey fee simple ownership of that property to APCO, nor did it give APCO the right to grant others the permission to build docks below the elevation contour of 800 feet. As stated above, the flowage easement expressly reserved to the grantors the right to possess and use said premises in any manner not inconsistent with the estate's rights and privileges herein granted to APCO. Meaning, what we granted APCO to flood was fine, but we retained the use of everything else on that property so long as we did not interfere with their ability to flood and operate the project. Thus, the existence of such a flowage easement did not deprive the grantor from exercising the rights of fee simple ownership that were unaffected by that flowage easement. Pretty powerful words, and it's precedent setting. Well, in 2001, Appalachian felt it was extremely important to file a friend of the court brief to the Supreme Court, an amicus brief. And their words are captured below. Under the flowage easement at issue here, the Yacht Club plainly retained the right to possess and use the premises in any manner not inconsistent with APCO's rights under the easement. Moreover, to deprive the Yacht Club of its fee interest in its land would be tantamount to an unlawful and an unconstitutional taking in violation of the taking clauses of Virginia. The 5th and the 14th Amendments of the United States Constitution provide similar protection. It has long been established that the federal Constitution forbids the taking of property without compensation no less through its courts than through its legislature. These were Appalachian's words to the Virginia Supreme Court. Ironic. Ironic in that today Appalachian is insisting that they can violate the flowage easement agreement they made with us and force us to sign a permit that strips us of those rights that were agreed to back in 1960. Powerful stuff here. This is what the law says. This is what Appalachian believes, so long as it affects them. The reason they filed this amicus brief was because there was a threat that the land the Yacht Club owned could revert to the state. And if it reverted to the state, Appalachian would have lost its flowage rights. And consequently, it was in their interest to defend property rights in Smith Mountain Lake Yacht Club versus Ramacher. Well, the last case that we're going to discuss today is the Anderson versus Delory case, which came before the Virginia Supreme Court in 2009. This case is important because it puts in perspective how to read the easement. Appalachian would like to read the easement today under its new and most recent license requirements, but this case tells us no, that flowage easement needs to be read as it was agreed to back in 1960. And here's what the court wrote. A deed may expressly create an easement but fail to define specifically its dimensions. When this situation occurs and the deed language does not state the object or the purpose of the easement, the determination of the easement scope is made by reference to the intentions of the parties to the grant, ascertained from the circumstances pertaining to the parties and the land at the time of the grant. 1960, not 2015. Therefore, we conclude that the record before us fails to support the Andersons' claim of encroachment based upon their theory of extended lot lines, and that the Circuit Court was not plainly wrong in refusing the Andersons' request for injunctive relief. Well, what we're talking about with extended lot lines are the imaginary dotted lines that Appalachian assumes extend out from the lots into the water. The court here said if that was not in the easement, and it's not in the flowage easement that we agreed to, then they don't exist, and one cannot quibble over whether or not their access to the project is limited because a dock barely crosses the line, or some beach or other measure crosses the line, this imaginary line, below the contour of 800, unless those people specifically own the land under the water. It's a powerful finding here, because Appalachian is restricting folks from building docks on lots because of the way they believe extended lot lines should exist, and they have no right to do that. So we're at conclusions. Let's see. We've learned that Appalachian misrepresented the extent of its property rights in its drawings, and that its drawings don't meet license requirements. We've learned that FERC has ordered that all property disputes are to be settled in state courts. Appalachian's not doing that. They continue to file lawsuits against individuals in federal court. APCO has no regulatory power over property owners beyond its property interests. If it doesn't control it, it can't regulate it. It's as simple as that. APCO only has a flowage easement, which is a right to flow the water up to 800 foot, and they have a right to use that for flowage purposes. And APCO has no authority to deny reasonable access to the lake, nor does it have the right to dictate how landowners use their property. I think we've learned that Appalachian is in violation of its license and state law. Well, what can we do to stop this taking of our property rights? How can we save our property rights? Let me suggest a donation to C.U.R.B. C.U.R.B is a 501c4 not-for-profit corporation registered in Virginia. Its purpose is to educate and inform citizens of the importance of their property rights, because through education we can save your property rights. Besides that, your donations will help support the ongoing litigation that Appalachian has brought against citizens in this project and litigation that we're going to bring against the FERC in the future. Thank you for your interest in this, and I hope you agree that Appalachian is clearly in violation of its license and Virginia state law. Thank you.